Public Employment Relations Commission on consolidated unfair labor practice complaints filed against the state of Washington by Washington interpreters and the Washington Federation of State Employees. The case numbers are 133420-U-21 and 134289-U-21 respectively. My name is Michael Snyder, and I'm the hearing examiner for the commission. My role is to be an impartial judge. Can the parties please identify themselves for the record? First, for Washington interpreters.
Good morning, everyone. My name is Juan Bloise. I'm representative for Washington Interpreters, ULP 133420-U. And we're here today to show...
Hold on, Mr. Bloise, hold on. We'll get to opening statements in a little bit. I'm just trying to get the parties' representatives on the record first. Thank you.
Thanks.
All right, and for the Federation?
Yes, Ed Younglove, attorney for the Washington Federation of State Employees, with me is Herb Harris.
Thank you. And for the state of Washington?
I'm Katie Garcia, my co-counsel at Carol Wolf, and we represent the state of Washington, the Office of Financial Management, and the Department of Labor and Industries in this proceeding.
Thank you. Are there any other appearances? Let the record show no response. This hearing is being conducted entirely by video conference. For the record, is there any objection to utilizing this process for the hearing? I hear no objection. Thank you.
Sorry, the Federation does object to the use of the recording under the, it's our understanding that the only official record is that the court reporter that FERC has retained, and in addition, we're concerned about the use of any recording in any electioneering.
Thank you, Mr. Younglove. You are correct that the only official record of the proceeding is the one created by the reporter. To the extent that anyone in the hearing room is recording the proceedings, I believe that pursuant to the regulations implementing the State's Administrative Procedures Act, I'm required to permit that, provided that the recording does not become disruptive. But your objection's noted for the record. But I don't hear any objection to the utilization of Zoom generally to conduct the hearing. During our pre-hearing conference conducted several weeks ago, the parties to this proceeding were advised to notify me immediately if there was any technical difficulties with audio, video, or other means of communicating verbally or with the exhibits. This is a public hearing. To the extent that there are any observers, they'll have their audio muted and video disabled so that while we cannot hear or see them, they will be able to observe the hearing. The purpose of this hearing is to receive evidence so FERC can resolve this dispute under Washington state law. I've reviewed the preliminary rulings issued in these cases and have compared the complaints and answers. I'll be limiting the scope of the hearing to the issues framed by those documents. The complainants are responsible for presentation of their cases and have the burden of proof. The respondent is responsible for presentation of its defense cases and has the burden of proof on affirmative defenses. The reporter is hired by the commission to record everything that is said in the hearing room while on the record, while the hearing is in session but can only record one speaker at a time. As a result, if you want to speak off the record, please direct your request to me rather than the reporter. If an objection is made, the witness should stop talking until I rule on the objection. When making or responding to objections, please state your reasons as concisely as possible. Standing objections may be permitted to an entire line of questions. If you want any changes made in the record after the transcript is issued, please send any proposed or stipulated corrections to me as well as the other parties. The reporter prepares the only official transcript of these proceedings, and all citations and written arguments must refer to the official record. The reporter reserves the right to sell copies of the transcript. If you want a copy, please make arrangements with the reporter during a recess or after the hearing. The parties are put on notice that evidence and information elicited by leading questions during direct examination is neither credible nor of probative value. Even without an objection from other parties, I may give limited weight to the evidentiary value of evidence introduced as a result of leading questions. At this point, are there any preliminary motions?
The Federation moves to sequester witnesses.
Any objection to the Federation's motion to sequester witnesses?
No.
Mr. Bloise for Washington Interpreters?
No.
Thank you. The motion is granted. So what that means is that witnesses in this proceeding will be sequestered. One witness will not hear the testimony of another witness until the hearing is closed. The witnesses are not to discuss their testimony, the questions they were asked, or anything about the proceedings with their fellow employees or with anyone else who is associated with the case. They may, of course, however, discuss their own testimony with the attorney or representative of the party who called them as a witness. So I'd like the parties to identify their table representatives for the record. So, Mr. Younglove for the Federation.
Yes, so the Federation's representative is Mr. Herb Harris. He's the Director of PERC Activities for the Washington Federation of State Employees.
Thank you. Mr. Bloise for Washington Interpreters.
Our table representative is Anastasio Lepe. He's the Vice President of our organization.
All right. Mr. Can you spell Mr. Lepe's first and last name, please?
A-N-A-S-T as in Tom, A-C as in cinnamon, I-O, Lepe, L-E-P-E.
Thank you. And for the state.
For the Department of Labor and Industries, the state has Emily Stinson, and Stinson is S-T-I-N-S-O-N. And for the Office of Financial Management, we have Valerie Imbrasado.
Thank you. Are there any other preliminary motions at this time? All right. Hearing none, during off-the-record discussions, it's my understanding that the parties are willing to stipulate to a substantial number of the exhibits that have been uploaded into the parties' respective proposed exhibit files. I'm going to go through my understanding of the parties' stipulation. Please correct me if I get any of this wrong. So first, with respect to the state's exhibits, all parties are willing to stipulate to the admission of the respondents' exhibits 1 through 17. Is that correct? First for the Federation?
Yes, the Federation so stipulates.
And for Washington Interpreters?
Yes, we stipulate.
Thank you. It is also my understanding that the parties are willing to stipulate to the admission of the Federation's 11 exhibits. So that's going to be, they'll be marked as WFSE exhibits 1 through 11. First for the state?
Yes, that's correct.
Thank you. And for Washington Interpreters?
Yes, that's correct.
Thank you. So with that, I will admit the Federation exhibits 1 through 11 and the state exhibits 1 through 17. It's my understanding that the parties are also willing to stipulate to most of the exhibits Washington Interpreters have uploaded into the proposed file. It sounds like, based on our off-the-record discussions, the easiest way to do that is to cover the exhibits that are not stipulated to. There are 40 exhibits in the proposed file right now. It is my understanding that the parties are not willing to stipulate to Washington Interpreters exhibits 17, 18, 19, 26, 30, then 35 through 40, which would mean that Washington Interpreters exhibits 1 through 16, 20 through 25, 27 through 29, 31 through 34, the parties are all willing to stipulate to. Is that correct? First for the state?
Yes.
And for the Federation?
Correct.
Thank you. So with that, the exhibits, Washington Interpreters exhibits that I have just mentioned are received. These stipulated exhibits have now been uploaded into the formal exhibit file. It's my understanding that there are no further pre-hearing issues to be addressed by any party. So with that, I'd like to move on to opening statements. First, let's begin with Washington Interpreters. Mr. Bloise?
Thank you, Mr. Snyder. Washington Interpreters is here to show that LNI's decision to overhaul the means by which providers acquire appointments through implementation of the Interpreting Works online scheduling system is a significant change to the status quo during the pendency of a representation petition at PERC and constitutes an unfair labor practice. Number 2, interpreters' wages, hours, and other terms and conditions of employment were dramatically affected, harmed by LNI's implementation of the Interpreting Works online scheduling system. Number 3, the assignment of interpreters' appointments is within the scope of bargaining. And lastly, number 4, implementation of the Interpreting Works online scheduling system was not part of the dynamic status quo. LNI's implementation of the Interpreting Works online scheduling system was a discretionary choice.
Thank you. Mr. Younglove, would you like to make an opening statement for the Federation?
Thank you, I'll reserve.
Sure. All right. So with that, anything further before we proceed with witness testimony? All right, hearing nothing, Mr. Bloise, you may call your first witness.